In earlier days of practice in court proceedings, the person who filed the suit must get into the box and give evidence. The court will record that evidence in its notes paper, or at present the technology has reached a better development. The stenographer or the typist will be there to assist the court, and she will be typing and recording the evidence given by the party in the system. Later stage, for such giving evidence and cross-examination and recording those evidence and the time consumed by the advocate while completing his evidence, a sizable time, functioning hours of the court is consumed. For example, for a particular day, 50 cases are listed for hearing or recording evidence, and after giving the inability or not ready matters adjourned, 20 cases is taken for recording evidence. Then both sides readily available parties and advocates will be requested to adduce their evidence. Then the person who filed the case will get into maybe plaintiff or petitioner may get into the box and give his facts of the case and the relief sought for, and he will be marking the required documents relied in the support of his case. That is called chief examination. And after that, the opposite parties, the defendants in case of suit, the respondent in cases of petitions, the respondent's counsel will be requested to cross-examine the plaintiff or the petitioner. He will start his cross-examination, and the witness is in his hands. So in order to disprove the fact of the case of the petitioner, the respondents or defendants counsel will do the cross-examination by putting various questions and eliciting from him certain points which will be later helpful to disprove the case of the plaintiff. That is called cross-examination. It is an art. But for cross-examination, the respondent's counsel, defendant's counsel, would make a request to, with this I am stopping this. For continuation of cross-examination, you give another date. So automatically the court, this fellow is having the court would have understood, since he is having a weak case, he is prolonging the matter. So you will be giving a date to him. You conveniently you gave a date and you come there on the day. Then date will be given. So this kind of delaying tactics has become a hurdle to the court functioning hours, and in order to reduce those elaborate proceedings and to save the valuable time of the functioning hours of the court, the necessary amendment has been made in civil rules of practice, wherein instead of giving chief examination orally, let all the chief examination be directed to be filed in manuscript by typing it or getting it in written. So hence that regarding the evidence in chief examination is later stage termed as by filing proof affidavit. So the proof affidavit means the chief examination of the petitioner or plaintiff narrating the facts of the case and the reliefs sought by him, and it should conclude with the prayer for which the relief is sought, and also it should contain what are all the material evidence, namely the documents or exhibits. He must chronologically narrate it and file it. This is called proof affidavit. To avoid the lengthy time in recording evidence, the court has introduced the procedure of filing the chief examination by way of proof affidavit.